Welcome to this video on the harsh reality of maintaining lawful permanent resident status while abroad during a health crisis. We will cover the one-year rule, the SB-1 returning resident visa, and actionable steps to protect your status. Let's begin by setting the stage, and then move into a clear plan you can follow. Here's today's roadmap. First, we'll establish why this topic matters. Next, we'll provide a necessary disclaimer. Then, we'll explain the 12-month rule and the SB-1 returning resident visa. After that, we will present a practical action plan and a documentation checklist. We will also visualize the process with diagrams, address common myths versus realities, test your understanding with quick quizzes, and finish with key takeaways. Before we dive in, an important disclaimer. This video is for general educational purposes only and is not legal advice. Immigration law is complex, and policies or procedures can change. Your circumstances may require specialized guidance. Therefore, you should consult a qualified immigration attorney for advice tailored to your situation. With that in mind, let's proceed to why this topic is so critical. Many lawful permanent residents face severe health challenges that require extended treatment abroad, including mental health care. However, U.S. immigration law presumes abandonment of permanent residence after an absence of 1 year or more from the United States. Consequently, balancing medical necessity with strict legal obligations is essential to protect your status. Next, let's unpack the 12-month rule so you're clear on the stakes. Let's clarify the 12-month rule. If you are outside the United States for less than 1 year, you can typically re-enter using your green card. However, once your absence approaches or exceeds 12 months, your permanent residence is presumed abandoned. Importantly, the physical card's expiration date does not protect your status while you remain abroad. The clock on abandonment is what matters. Therefore, track your days carefully and prepare documentation early. Now, having framed the rule, we will move to the SB-1 returning resident visa, which may be the only path back if you exceed the 1-year mark for reasons beyond your control. The SB-1 returning resident visa is designed for permanent residents who remained outside the United States for 12 months or more due to circumstances beyond their control. To succeed, applicants must establish two separate elements. First, that the extended stay was due to factors they could not control, such as medically necessary and continuous treatment. And second, that they maintained clear, continuous ties and intent to return to the United States throughout their time abroad. This is not a simple renewal of a document, but a rigorous assessment by the consular officer. You apply at a U.S. embassy or consulate, complete forms, pay fees, attend an interview, and provide substantial evidence. Next, let's translate that into a concrete action plan. Here is your action plan. First, document medical necessity immediately. Obtain detailed physician letters describing the diagnosis, required treatment, duration, and why returning to the United States is unsafe or impractical at this time. Second, preserve U.S. ties by filing resident tax returns, maintaining U.S. bank and credit accounts, retaining a U.S. address and property or lease, and keeping a U.S. phone line. Third, show ongoing intent to return by maintaining employment links where possible, enrolling in remote studies, holding memberships, and keeping U.S. insurance active. Fourth, track your absence with calendar alerts at 6, 9, and 11 months to avoid crossing the 1-year threshold unexpectedly. Fifth, if exceeding a year is unavoidable, prepare an SB-1 application, compile evidence, complete necessary forms, pay fees, and schedule the interview at the U.S. Embassy. Finally, organize an unmistakable paper trail by labeling documents, providing translations where appropriate, and writing concise summaries that directly connect your evidence to the two SB-1 requirements. Next, let's convert this plan into a practical checklist. Use this checklist to assemble your evidence. Medical records substantiate circumstances beyond your control. Tax filings, financial accounts, and residence documents demonstrate continuing ties to the United States. Employment or educational links reinforce your commitment to return. Travel records clarify your timeline. Communications show ongoing intent to return. A reentry permit, if available, may contextualize longer absences. Finally, attorney letters can present a concise legal summary of your supporting materials. Now, to clarify timing pressure, let's visualize the journey with a timeline. This timeline shows the critical phases of an extended absence. From departure through months 6 and 9, you should maintain U.S. ties and gather medical documentation while preparing contingencies. By month 11, escalate preparations. LEs. At month 12, the presumption of abandonment is triggered. If your absence will extend beyond 12 months, file the SB-1 application at the U.S. Embassy, attend the interview, and await a decision. If approved, you may return to the United States as a returning resident. If refused, you may need to explore alternative immigration paths. Next, we will illustrate the process interactions using a sequence view. This sequence diagram outlines the interactions among the key participants. The LPR gathers medical and tie-related evidence. The treating physician provides detailed letters explaining the necessity, duration, and continuous nature of treatment. The U.S. Embassy receives and adjudicates the SB-1 application, potentially requesting additional documentation and conducting an interview. If approved, the LPR travels to the United States and presents documents to Customs and Border Protection, which then makes the final inspection and admission decision. Now that you've seen the flow, let's confront common myths and compare them with the legal reality. Let's clear up misconceptions. The expiration date on the card does not govern abandonment. The duration of absence does. A medical crisis does not automatically shield your status. You must prove both circumstances beyond your control and continuous ties and intent to return. You typically cannot resolve a 12-plus month absence merely at the airport. You likely need an approved SB-1 visa first. Lastly, isolated documents rarely suffice. A thorough, consistent paper trail is usually necessary. Up next, a quick knowledge check. Quiz time. The question is, which factor primarily triggers the presumption of abandoning U.S. permanent residence? Option A, expiration of the physical green card. Option B, total time spent abroad reaching or exceeding 12 months. Option C, having medical bills abroad. Option D, changing your U.S. mailing address. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. The presumption of abandonment is primarily triggered by the total time spent outside the United States, reaching or exceeding 12 months. It is not driven by the physical card's expiration date. Second quiz. The question is, to succeed with an SB-1 returning resident visa, what must you prove? Option A, only that your absence was beyond your control. Option B, only that you kept some U.S. bank statements. Option C, both that your absence was beyond your control and that you maintained continuous ties and intent to return. Option D, nothing. SB-1 is automatic for medical reasons. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. You must prove both that your prolonged absence was due to circumstances beyond your control and that you maintained continuous ties and intent to return to the United States throughout the period of absence. Here are practical do's and don'ts. Do continue filing resident U.S. tax returns, maintain a U.S. address, financial accounts, and insurance, and keep medical documentation up to date. Set reminders at 6, 9, and 11 months, and prepare an SB-1 application early if timely return is impossible. Do not assume the card's expiration date protects you while abroad, and do not wait until arrival to explain a 12-plus month absence. Avoid relying on a single piece of evidence. Translate and organize documents thoroughly, and consider consulting an experienced immigration attorney. Next, we'll reinforce the core takeaways. The essential points are as follows. The duration of time abroad drives the presumption of abandonment, with 12 months being critical. The SB-1 visa is challenging but achievable, with strong, well-organized evidence. Medical necessity must be thoroughly documented and show continuity. Maintaining U.S. ties, tax filings, financial accounts, address, and property is crucial. Finally, organization and consistency across your documents can make the difference. We will now summarize the full discussion. To summarize, permanent resident status depends on maintaining residency, and an absence of 12 months or more triggers a presumption of abandonment. If you must stay abroad beyond a year, due to circumstances beyond your control, the SB-1 returning resident visa may be your pathway, but you must also demonstrate continuous ties and intent to return. Acting early by documenting medical necessity, preserving U.S. ties, tracking your days, and preparing a meticulous evidence package can protect your status. As we close, we will remind you of the disclaimer and invite you to engage further. As a final reminder, immigration laws and procedures can change, and individual facts are decisive. Please consult a qualified immigration attorney for advice tailored to your circumstances. Now let's wrap up with how you can support this channel and continue the conversation. Thank you for watching. If you found this helpful, please like the video, share it with someone who needs this information, and subscribe for more step-by-step guides. What's your biggest question or challenge about maintaining permanent resident status during a health crisis? Share your thoughts in the comments. We look forward to hearing from you.